listening to Estate at the Union, estate planning made simple. Here's your host, Brad Wewell, from Texas Trust Law in Austin, Texas.
Hi, this is Brad Wewell with Texas Trust Law. This is our podcast, The Estate of the Union. We have a lot of podcasts, and this one is special. This is going to answer the question that you have got rolling through your head many times when you even think about doing estate planning. And that is, well, what if I don't do any planning? Where does it go when I die? If I die without a will, without a trust, without diddly squat, okay? Ann Lumley is here. Ann is our Director of Afterlife Care. Now, what that means is Ann is an attorney. She's an excellent attorney. And she is the woman, we have another attorney, Philip Arundel, who you meet with when you've lost somebody. And if you come in with a will and has one procedure, if you come in with a revocable living trust and it's a separate procedure. And if you are the unfortunate family member who comes in here because you lost someone who doesn't have a will or a trust or anything, and that is, what was that word again? The unfortunate ones who come in like that. And we have lots of them coming in like that, right?
It's one of my hardest initial administration
It has to be.
meetings because I'm often delivering surprising news.
And oftentimes bad news, right? So we're going to go through that. This is what we're going to do today. We're going to teach you what happens. So hopefully, ladies and gentlemen, please, you'll actually get some of this stuff done. And you know, if you watch any of our other stuff, you can call Texas Trust Law at 512-480-8828, or you can go online at texastrustlaw.com and set a free consultation to get this stuff done. But that's not why we're here. We're here to talk about what happens if you don't. So, Ann, I'm going to ask you some softball questions, and you're going to take the bulk of this. When I come in, let's say I come in, I've lost my dear Auntie Evelyn, and Auntie Evelyn did not have a will, and I'm here to talk about that, or my spouse died, or my parent died. What do you need to find out first? What's going to be part of your analysis here?
Well, first, I need to know whether it was your auntie or your spouse or your father, because you need to know the family structure, because everything in intestacy law is dependent on family structure, who survived, and then what type of property we're talking about.
So family structure, again, whether you're related to the decedent by, again, I'm the nephew, I'm the spouse, I'm the kid, whatever.
Yes.
Okay, all right. What would be next?
What type of property is in existence and how it's titled.
All right, so let's back up. What kind of property? So like I got a car, I've got a bank account, or are you talking a little more legal, nuanced stuff?
Both. So the first thing I always talk about is whether we have probate assets or non-probate assets, because a will or intestacy law is only going to apply to probate assets. So if you have life insurance or something that's beneficiary designated,
An IRA perhaps?
yes, or a joint bank account with right of survivorship and you're the surviving spouse, those, it doesn't matter that you don't have a will for those particular items because they'll pass according to that bank account
They're going to go
agreement.
directly to the...
Yes, how they're designated.
To whoever the beneficiary is.
Yes, so they would not go through the court system. So only the probate assets go through the court system, and that's when it matters what method you can take, whether you have a will or don't have a will.
So we talked about probate assets. Let's define probate assets.
Probate assets are assets titled just in the person's name, the person that passed away, just in their name, without a pay-on-death designation, without right of survivorship, and without a beneficiary designation.
Could it be my name and somebody else's name, though? Like
It could. You can have a joint account. That was something I didn't fully understand until I practiced this type of law. I went to law school in California, which has community property law, but slightly different community property law than what we have here in Texas. And so, yes, you can have right of survivorship on an account, and most of the time banks have as their policy their right of survivorship joint account. I mean, their joint accounts by policy typically have right of survivorship, but it's not set in stone. You have to find out, you have to look to the signature card when you set up the account. There has to be a proactive initialing by right of survivorship in order for it to automatically happen.
What if I've got a piece of real estate and I own it with Wade? Wade's our director, by the way, is behind the camera here.
Then you each own a half.
Okay.
And
is that a probate asset then?
It would be. Real estate is typically a probate asset.
Okay.
In 2017, Texas got transfer on death deeds, and so there's a way to avoid probate through a deed, but it's a proactive planning tool. It's not when you normally buy a house or buy any type of property, you're not going to get a transfer on death deed. It's something you have to go to an attorney to help you draft up as part of your planning. Normal deeds, you will have 2 names on the account, and this is a difference with California law as well.
Okay.
In California, when there's 2 names on the account, there is right of survivorship or on the deed, and it automatically goes to the survivor, and you don't have to go through probate for that. But in Texas, that's not the case, and that's often what most people find surprising.
Right. Okay. So we've got probate assets, non-probate assets. What's the next thing you're going to want to know?
You need to know if you're talking about personal property or real property.
Okay, let's define those, please.
So real property is what you would think of, land and then mineral rights. And personal property is pretty much everything else.
Okay.
Bank accounts,
yep.
even tangible personal property like your stuff, your knickknacks, your things around the house.
Okay.
Those are considered probate assets.
Okay, good. All right. So then we kind of know the relationships. We've got distinction between probate assets and non-probate assets. We got a distinction between personal property. So this book, we'll get to this book here in a few minutes, is tangible personal property. This is tangible. Money is intangible because you can't really drop it on the floor and have it affected by gravity. Real property is land. Okay. What's next?
Then we also have separate property and community property,
mamma mia.
because this is a
Holy
community
cow.
property state.
This is a lot of
And
analysis.
so community property is, that comes into effect when you're married.
Okay.
And the presumption is in Texas is that anything earned during marriage, it's presumed to be community property.
Okay.
You'd have to show that it was not community property. Anything that you owned prior to marriage is considered your separate property.
Okay.
Gifts and inheritances are considered separate property. But other than that, pretty much there's a few distinctions. I don't want to get too complicated on
Right.
community
Let's-
property
please
law.
not, please
but
not.
basically, it's all presumed to be community when you're married, unless you've inherited it or it was a gift
And of course, if you're
or
single,
had it before.
if you're single, everything's separate.
That's correct. Community property is only in effect if you are married.
Okay, got it. Okay, so that's the first thing Ann's going to do is make that analysis when somebody walks in because their aunt died, their spouse died, their parent died. You've got to go through this before you can even share with them what
Their options may be.
Yes, that's right. And we're going to get to the options next. And I want to say this about Texas law. I think Texas law is particularly harsh on people that die without a will, because we just talked about the California rule. Now, we're not going to get into California, everybody. But California, I die, I own it with Ann. I die, it's Ann's. She dies, it's mine. That is not the Texas rule. That is not. And if they're blended family and stepkids, and that gets worse, but we'll get to that. So stand by. We're going to talk about stepkids and blended families, and that's where it really gets
You
bad.
get surprises.
Surprises, right, Ann? Okay, thank you for that. Let's go to what do you want to talk about next? We have these cool charts that Ann brought over with her, too. So
Those are courtesy of Judge Herman off the
Okay.
Travis County Probate website. He
Good.
has a pie chart, pie graph to show you in the different scenarios what the intestacy law
nice.
breaks out.
Okay.
So yeah, my biggest surprise is with blended families. I think when a surviving spouse comes and their spouse passed away without doing a will, they may have been married for 30 years, but it's a blended family, and that matters. I've had to tell people, surprise, you now own your home that you've owned with your spouse for 30 years. Half of it's still yours because that's your half of the community property, but the other half is now owned by his children.
So let's go over that. This is the last thing you want to find out when you just lost your spouse. That you now own the house, and then you probably own the cars, and you probably own bank accounts and things like that, perhaps, with the deceased children.
Yes.
Whew. All right.
If you all get along and they're
Perfect.
willing to gift it, then you can get around it and you can do some paperwork and things to get it to you. I've had situations where they were grown children and they understood that this is, they'd put their money into it. But, and they decided to do like a contractual agreement of how they were going to distribute the assets more in line with what was expected. But that's not the law, and they don't have to do that. So the law is that the decedent's half of the community property, if they have children from another relationship, it's going to go, their half is going to go equally to those kids.
Right, and not to the surviving spouse.
Not to the surviving spouse, and it can become even more of a problem if those kids that are inheriting are minors, because then you have to worry about minors can't own property, and you have to have a guardian of the estate for these minors to receive this property, and that's a whole nother probate procedure.
Maybe your deceased spouse's ex.
You'll be dealing with the ex,
because
perhaps.
they would be the first in line to be the guardian.
They're the natural guardian, and they could very well become the legal guardian for that as well.
So you get to deal with your ex's ex, your deceased spouse's ex, over a lot of stuff.
Right.
Whew. All right. I did family law for 10 years, ladies and gentlemen. I had a heart bypass at the age of 43 from the stress of doing divorces and custody fights.
I did 4 months of family law before I came here, so you lasted longer than I did.
I did. I toughed it out until I got the call. Okay, so, and then there's a special rule. Anna and I were talking about this, ladies and gentlemen, before we got on here, about the 1993 rule.
Yes. So, like I was kind of saying, now it's harsher if you have a blended family for the surviving spouse, because Texas would now presume that if there's a married couple and all the kids are of the same marriage, then that share of the deceased person does go to the surviving spouse, because Texas presumes that the other parent will take care of the kids when they pass away.
So we could have put that in different context.
Yes,
Would that
you
be
can
okay?
make it more simple.
I'll try to make it more simple. So I'm married to Cindy. We have 3 children. All our children are our children. If I die without a will, Cindy gets all the community property because all the children are of our marriage. What we were talking about a minute ago, though, is if I had a child from a prior marriage, and then I married Cindy, and we had 3 children, if I died without a will, my 4 children will inherit my half of the estate, and Cindy only gets to keep her half because I had a child that wasn't of the marriage. Does that make sense? So if they're all of the marriage, she gets it all. One not of the marriage, 2 not of the marriage, the kids get it all of my half. Okay, so
I believe that's the intent behind the law, is to protect the children, so that if the other spouse is not the biological parent, they might not leave anything. It's just a lot of presuming going on, but there's no perfect answer. But either way, it just might not end up how you're expecting.
And it can be a horrible result. And let's go back to what Ann said at the very beginning. These are her hardest meetings. Delivering that kind of bad news.
Having to go to probate to do a full-blown heirship determination and have a personal representative appointed so that you can get your letters of administration and access accounts that have been frozen is the more expensive route than if you have a will. It takes longer. It's more complicated. You have to have an attorney ad litem appointed. You have to have extra witnesses come to court. It's just a much more complicated, expensive procedure than if you plan ahead and do your will
or do a living trust. You can do a
there are
trust,
other options.
Sure.
But
let's go back. Ann used a word that you might have heard, but I want you to hear very clearly, and that accounts get frozen.
Yes. Probate assets can get frozen. If there's an account just in someone's name and they pass away, you have to have a legal representative appointed by the court in order to access those accounts. And so there can be at least a month sometimes before you can get access to those funds. So you need to think ahead, because those people might be, your loved ones might be relying on those funds, and there's like a time period where they can't get to them.
You got a mortgage payment to make. You got maybe, again, a medical bill you have to pay, the light bill. Maybe somebody's in college. You have to pay tuition payments. It's, again, this is you're grieving because you lost somebody. And now you walk in here and you've got a lot of legal problems, and we're not going to go into fees right now, ladies and gentlemen, but you go to any lawyer with this mess, it's going to be an expensive mess.
It's not free.
It's not free. All right, so let's shift our emphasis just a little bit, because there's a distinction when somebody dies without a will, back to what you brought up earlier, personal property and real property.
Yes.
All right, so let's, if you don't mind, Ann, and again, Ann's our expert in all this stuff, and she's, again, excellent, and she'll be the one you meet with if something happens. She or Philip, tell us the difference of what happens if you die without a will regarding personal property, money, stocks and bonds, things like that, the book, the car, and real property, real estate.
Texas is weird with real estate. Texas is a land-rich state, but we have some weird rules with real estate. The most elusive thing I think I encountered was the 1/3 life estate that passes to a spouse if there's separate real property.
Slow down.
I figured we'd go back and look at it, but I'd throw out there, what is this 1/3 life estate?
1/3 life estate. So there you go, ladies and gentlemen. So why don't we explain that, please?
So first of all, let's look at a married couple with children, blended children, because that's where most of the surprises occur.
That's right.
And a lot of us have that these days. So if the husband passes away and there's a house, and maybe he had the house before they got remarried, it's his separate property.
And it's very common now, as everybody watching this knows, we get married. I had a house before we got married. We get married later. We move into my house. Or, I've seen this so much, and it's a really dumb thing to do. A couple has been living together, and they buy the house together. That's each of their separate property. And getting married doesn't change it into community property, does it?
I just had a situation where the couple, it changed everything, because I looked at the deed and found out they actually purchased the house a week before they got married. I mean, they were thinking we'll have the house to come back to after our honeymoon, which makes sense.
Sure.
But it completely changed how things were distributed, because it was each half separate property and not community property at the time.
Wow. All right. So
if we have a married couple, and it was the husband's separate property house before they got married, maybe they've lived there for 30 years now, you know,
sure. and put money into it and paid off their mortgage.
Yeah, they've community property payment, all of that. There's rights to reimbursement, but I won't go into that.
Right.
But basically, if the husband died without a will, his surviving spouse gets a 1/3 life estate, but the rest of the ownership of the house gets divided equally between his children.
So 1/3 life estate basically means she can live there, can't be kicked out.
Right. There's a separate homestead, probate homestead right to occupy for the surviving spouse. You can't get kicked out, regardless of ownership title.
But you die, you have no control of where it goes when you die, and you have a 1/3 life estate, which means that, frankly, if the new roof needs to be put on, you might have to kick in 1/3, and the kids have to kick in 2/3. But if the kids don't kick in 2/3, if you want the roof repaired, you're going to repair it and pay for the whole dang thing, and maybe you can sue the kids to get 2/3 back, but that's not practical, and that's expensive too. So it's a little vague.
There's like a table, kind of like for life expectancy tables for IRAs and things like that.
Okay.
There's a life estate table, and you can figure out based on the age of the person that has the life estate what that number is, and then you multiply it by the value of the house. So if you're going to sell the house, they will get a monetary value based off of their 1/3 life estate.
Okay.
But they couldn't just sell the house because they only have a 1/3 life estate to sell. All the kids would have to agree to it as well.
Wow.
So it just gets pretty complicated.
What about, I don't know the answer to this question. I'm going to ask Ann this. I've heard of it. What if the deceased died married, without children? So died without children. We're using the husband as our example. He dies because the guys always go first. Where does this half go then?
Well, are we talking about community property half?
Let's say it's a separate property.
Okay.
And let's say that it's real property, so it's the house. So he had the house where they got married. They never had kids together. He didn't have kids before they got married. Maybe she did. Doesn't really matter. Where does his half the house then go?
Well, he would own the whole house because it's his separate property.
Right.
And so half of it, I think half does go to the spouse.
I think that's
It's been a while since I've looked at it in that particular scenario, but I believe half goes to the spouse, and then the other half, If his parents are alive, a fourth goes to the mom and a fourth goes to the dad. If only one parent is alive and he has siblings, then I think 1/4 goes to the surviving parent and the other fourth gets divided equally between his siblings.
Now, you hearing this? So you're the wife, dead husband, no kids. He didn't have any kids. He dies. The house, now you're going to own it with his mother, his father, his siblings, right?
I believe that that's the case.
I think that is the case, and that is crazy. But that, again, folks, is what happens if you are not going to get a will or a revocable living trust. If you don't have a will or trust, we're talking reality here. This happens all the time, all over the state of Texas. It happens in this law firm way too much. If you really want to have fun, and y'all look like a fun bunch today, you can go online and get our book, the Texas Estate Planning Handbook. And on page, what do we say? On page 86 is the last will and testament according to the Texas legislature. This is kind of a recap of what Ann is telling you. This is the potential, I'll use that word, horror story you may be facing if that happens. Don't let it happen. Now, Ann, I'm going to shift our gears in the interest of time.
Okay.
All right, because we also have a lot of people who die, of course, who are single. Okay? If they die and they're single, where does their property go?
Well, you only have separate property. You don't have to worry about community property.
Right.
And it goes much like we were just talking about for the separate real property of the last example. So if you have children and you're single, it's going to all go equally to your kids.
Okay.
If you don't have children, then it goes up. It goes to your parents.
Okay.
Half to each of your parent if they're both alive. If one's alive, half to the surviving parent. If you have siblings, then the other half would get divided equally between your siblings. If you don't have siblings and you have a parent, then that one parent takes everything. If you don't have surviving parents but you have siblings, then all of it gets divided equally between your siblings.
And let's say I don't have a parent and I don't have siblings.
Then you get into the fun world of, I don't know how to pronounce the word, moiety.
It's called a moiety, yes. There you go, a nice legal word.
You keep going up. Texas has laughing heirs, which means you keep going back through the generations. And that was my one
you had a
newbie
case like
case
that. That's right.
where the person that passed away had her parents had both predeceased. She had no siblings, no children. We had to have a private investigator, like a genealogist. It's like a forensic genealogist.
Right.
They had to go back and trace the family tree. And so $10,000 later, because those were the fees for all of this, we found 50 living heirs spread out across the country. And I personally looked through the father's lineage, and he'd been, this is all turn of the century, and he'd had 2 spouses, and everybody had about 4 kids or 3 kids per marriage, and people had passed away having their 4 kids.
And passed away without a will, so you got to figure all that for them.
And you have to figure out their fractional shares, and you have different things. You kind of touched on it earlier. Stepchildren don't count for receiving intestacy law, but half-bloods and whole-bloods get different shares.
Sure.
And I kid you not, for one whole day of work, I spent 8 hours calculating the fractional interest shares for the 50 potential heirs in this one particular case. And some people were getting like 1/512th. And it was boiled down to maybe at the end of the day, $7,000. Like it was a very complicated administration for a not very large estate, and it took a total of almost 6 years because before you can proceed in the court, everyone has to be properly served, given notice, and you might send a letter saying you potentially are going to inherit and receive property, but they don't know who this person is, so they're tossing the letter, they're not calling back, they have to be personally served.
And they may think it's a scam.
Right.
Sure.
And people just don't like lawyers, even if you're going to get something. Like they just don't want to deal with lawyers.
So that's where the term laughing heir comes from, ladies and gentlemen. And used the term a minute ago. A laughing heir is when you get notice from somebody, hey, somebody died and you're entitled to an inheritance. You're kidding me. No, it's really true. Who died? Sally Smith and Bug Tussle, Texas died, and you're the 153rd cousin, and we got a check for you. Ha! So that's where the term laughing heir comes from. And the irony of all this, and the tragedy of all this, is that the lady who died could have left it to anybody that she wanted to, her best friend, her soulmate, her partner, her favorite charity, and didn't, and now created all this mess, and the people are getting it, have no idea who she was, and flicker like that. Thanks for the money, whoever you are. What a tragedy.
That would be my biggest takeaway from being this type of an attorney and dealing with all sorts of administrations and family structures and things like that. The hardest thing, like I said, is telling people that the stuff's not going how they thought it was going to go. And a lot of times people don't think they have enough to have an estate, so that it's not worth it to do planning. But sometimes that's the most important, because you want to make sure that the little bit that's there goes where you want it to go at the least possible cost, so it stays with your family.
In legal fees and
because you could avoid probate. You could. There are a lot of tools that you can do to avoid those legal fees.
Sure. So just again, the smaller estates, these fees take a much larger chunk out of a smaller estate. So yes, get a will. We do wills. We offer free consultations. I said at the beginning, I'm going to repeat this right now. You can call Texas Trust Law. You can go online at texastrustlaw.com. We got all kinds of things you can click on our website to set up an initial consultation, a free initial consultation. Somebody asked me yesterday, well, do you do simple wills? Yeah, we do a lot of simple wills. We're happy to do simple wills. We just wanted you to get this. We'll also do a financial power of attorney, a medical power of attorney, so somebody can make a medical decision for you. We have all this stuff that we're going to give you if you come in here to do a simple will. So, by gosh, get off your duff and get this stuff going, right?
I primarily just administer estates, but I do also do some planning. Sometimes my clients, they have a relationship with me and they ask me to do it, or people will do that. And I have a different perspective from the administrative point. And what I always tell people is, what a blessing you are doing for your family by getting this in order. Because I see people, they are grieving. It's fresh. It's hard to focus. And the last thing they want to do is come hear some surprising news and have to deal with all like a more complex administration.
Right.
So I like the ones where I can say, well, because of your planning, there's really very minimal that we have to do, and we can take that. You know, they planned ahead so they'd have less of a burden on their family afterwards.
That's right. So be smart, be wise, be with it, and get it done. This is Ann Lumley. She, again, is Director of Afterlife Care here at Texas Trust Law. I'm Brad Wewell. We have 7 lawyers here. We'll match you up with the right one to help you get it done. Yes, if you're married, you have to come with your spouse. If you're living with somebody, if you have a partner, you have to come separately. It's kind of interesting. We only see married couples together, but we'll only see people who aren't married separately because of conflict of interest rules and things like that. But come on in. First visit's free. If you like us, you can hire us. If you don't like us, you don't have to hire us, but at least you'll get started on something. So, Ann, great presentation.
Thank you.
Thank you very much. And thank you for watching, and thank you for being a part of our family here at Texas Trust Law. We'll be back with another podcast soon.